I'm not going to ask.
We only take good cases.
Oh.
So John and John are out.
John and John are out. All right, we are now recording. We have Walter Luers, who is like the OPRA champion attorney. Like basically, Berkeley Heights is funding half of his life at this point.
Do we applaud him? Should we all stand up?
We let's applaud him.
Yeah.
All right. Before we get started, though, Walter, I want to kind of show you something. I want your opinion. Okay, this is a serious matter. All right. And I want you to tell me what you think about this.
One timeout. They'll save that for the field goal. If they have to. We are seeing another spectacular effort by Marino, who fires.
We love you, Danny. We love you.
He's going to kick the ball toward.
He was. Aaron Glenn wasn't fooled. Aaron Glenn stayed with the receiver. So.
Right. So, what's your legal opinion about that?
My legal opinion is that it wasn't as bad as the butt fumble because I was at that game.
Oh,
it's way worse live.
It's way worse live. All right, so let's get serious. Enough of this shit Leo tries to pull.
I didn't do anything today. I'm not yet.
Right. So Walter, you're like you really have been a huge help to sort of parents and to community members who've been trying to get information from the district. And if you can start, like, just give us a little bit of background as to your experience and how you got into sort of I think OPRA and OPMA are both sort of areas of expertise for you, right?
Yes, they're areas of focus. I'm not allowed to say that I'm an expert, but
okay. I am. I can say that. I'm an expert.
You can say whatever you want.
Yeah.
I can't call myself an expert. I mean, it goes back to, I think, 2006, 2007 when I met John Path, and he was.
Oh, I know John Path. He's awesome. Go ahead. I'm sorry. I don't know him. I Facebook know him. Sorry about that.
You can drop it anytime. And he was actively looking for attorneys to handle OPRA cases, and he sold me on the fact that there was fee shifting, and there's a lot of different statutes where there's fee shifting: antitrust, consumer fraud, wage and hour. So the fact that OPRA had fee shifting wasn't particularly unique. It's just that no one was using it, and then still, I think it's still not used a lot. I think in terms of the denials and the amount of opacity there is, I can see there being many more OPRA cases. But back in 2006, there were very few. And John Pav and I started working together. And then we started working with other people. And then from there, it grew.
What's fee shifting, Walter?
So fee shifting is when if one party wins a case, the law gives the winning party the right to have their attorney's fees reimbursed or paid for by the losing side. So oftentimes that's in place because of some type of power imbalance. So, for example, in OPRA, when we sue places like Berkeley Heights, well, they've got several law firms, and their lawyers are over there, and they're funded, and the whole thing. Whereas, most people like yourselves, you don't have like extra money lying around just to, hire lawyers. And even if you did, I'm not sure I would tell you to, because you probably got other things to do with your money, like pay for college and pay mortgages. So fee shifting is meant to promote a specific public policy, which in this case is transparency, and to level the playing field between government, which is extraordinarily well funded. I mean, there's essentially no limit on the amount of money they can raise, right? Because they just keep taxing.
Yeah.
And people like the people on this Zoom call, which you're just ordinary folks trying to make a living, as opposed to being extraordinarily wealthy and just being able to fund litigation.
So, and I'll ask one more question, and we'll move to different people. So, why is OPRA important? Like, do you mind kind of explaining the purpose of OPRA, why you feel it's important, and what OPRA has done for communities like Berkeley Heights?
Well, I think if folks know that other people are watching what they're doing and how they're doing business, it's more likely that they'll go about it honestly. I mean, unfortunately, folks break the law all the time. Now, not every time that they break it, it's because someone's got criminal intent or maybe someone's making a mistake. But there are plenty of instances where there's payouts, or folks are hired who shouldn't be hired, or folks have conflicts of interest, or payments are being made for overtime that shouldn't be made. I mean, that happens all the time. And sometimes it's because, folks know they're not supposed to be doing it. But it could also be through a good faith mistake. But regardless, transparency allows that sort of, it makes it more likely that sort of thing is exposed and corrected.
Great. Go ahead, John. I think you had some questions about the state.
So, is fee shifting threatened at all by any changes coming up, or is that going to stay? Because it sounds like that makes sense to have that in place for OPRA law specifically.
I mean, I'm not aware of like any specific threat. I mean, it is true that with every new legislative session, folks introduce prior bills that were never passed. And some of those bills advance OPRA and they advance the Meetings Act, but others, in my view, don't. And so right now, there's almost certainly a handful of bills that would modify or eliminate fee shifting in OPRA. But fortunately, in my view, they're not anywhere where they're likely to pass. We have things we look at to see, okay, is this getting close to being passed or not? So I don't want to tempt fate, but so far so good. But it's an excellent question because it's something we're always focused on. Because yes, if you take away fee shifting in OPRA cases, then you're going to get as many OPRA cases as you get Meetings Act cases, and there's very few Meetings Act cases because there's no fee shifting for the Meetings Act.
So big picture, I wanted to see, like, we seem to complain that we're using OPRA a little bit more here, or apparently we're not, but they're trying to make the case that we are at the school level, at the BOE, and we're trying to get information. It's the only way we're getting transparency, and every time we do it, it does reveal that they actually have a poor transparency policy right now, which is telling. But then there's also OPRA you get at the town side, the local government side. So I want to ask them two big picture things. Are you dealing with a significant amount of more of OPRA issues at the Board of Ed side or the township side? And what's the layout look like compared to Berkeley Heights? How does it fit in the rest of the state?
Well, I mean, in terms of Berkeley Heights, I mean, they're turning themselves into an outlier in my view. There's some towns I never hear about, and there's other towns folks come to me once in a while, and then there's others where it's just like repeat players. And I think that most places have at least decent to good cultures of transparency, because the more you deny OPRA requests and the more litigation you get, then the more OPRA requests you get, because people don't trust what's going on. And I think that's what's happening in Berkeley Heights. I think in general, there's a little bit of a lack of a culture of transparency. And so the solution to that is not to defend suits and defend opacity, but it's to just increase transparency. Because if folks like you have the sense that there is a culture of transparency, you're probably going to file fewer OPRA requests, there'll be fewer denials, and there'll be less litigation. So that's the cycle you get. And I'll say I think most boards and most clerks do a good job, because there isn't an avalanche of OPRA litigation. In terms of appeals, I try to follow all of the appellate division OPRA appeals, and you get, I don't know, like 10 or 20 appeals a year that we read about. And GRC is doing like 300 to 500 cases a year in terms of their new filings. I mean, I think it could be a little higher. So if there's like 1,000, let's assume there's 1,000 cases between Government Records Council and Superior Court. Let's just assume there's 1,000. Well, there's probably millions of OPRA requests that are fulfilled. I mean, I know there's some agencies, state agencies, they receive tens of thousands of OPRA requests a month. So I think when you're talking about litigation in terms of what actually gets fought, you might be talking about, I don't know, 0.001% of all requests, which tells me that most folks are doing a good job most of the time.
Laura, Shauna? I'm sorry, John. Maybe you cut you off. You had another question?
No. Go ahead.
I guess if you could speak to OPRA reform we've heard about that's happening at the state level. If you have any insight or where the direction you see that possibly going, what that means for people like us who are, at the end of the day, trying to make our local governing bodies more transparent and accessible.
All right. I mean, OPRA at this point is over 20 years old. So I think that there probably are aspects of OPRA that could be modernized. I think that the more information and records that gets put on the internet, I think that's better. I think that if an OPRA request asks for information that's on the internet, on the municipality's website or the public agency's website, a referral to the website and maybe a link should be sufficient. So I do think there's aspects that could be modernized, but it becomes like a Trojan horse issue, because if the goal is just to increase the burden on requesters and increase the burden on the public and maybe chip away or reduce the rights of fee shifting, then no, that's not something that I would support.
Shauna, any questions? Okay.
Tell me about 6 children.
Oh, all right.
I heard you have 6 children.
Yeah, so sounds like someone's been looking at my bio. Yeah.
Yeah.
I
mean, Laura and I have 4. We each have 4, but 6, I don't know. And 2 dogs, yeah.
Is that why you decided to come here, Walter, to get away?
Yes, I'll answer for him.
Yeah. It's a little bit of a sad note. It's 1 dog now.
Oh, I'm sorry.
We had to euthanize one of them, and you know what? I purposely haven't changed that bio to say 2, just as like a little bit of a memoriam for him.
Yeah.
Very much.
Oh,
But,
I'm so sorry to hear that.
yeah.
Hey, Walt. The way sorry, Walter.
That's fine.
The way I see it when I'm trying to push in this informational to the public is that people have very little power. I feel like right now it's voting when they feel like there's a problem, and then really OPRA, and I feel like that one's a little bit under threat. So I feel like there's like a little bit of a power imbalance. Do you see that's becoming an issue, and do you feel like there's a power imbalance, or is that correct? It's just OPRA and voting, and that's all we have, and we have to act if we see that there's a problem?
No, I mean, I think there's a little bit more than that. I think there's public participation. You still have the right to go to the meetings and be heard and be persuasive. There's still something to going to a meeting or watching a meeting virtually and publicly participating, trying to be persuasive. There's still an art to that. I think one of the biggest challenges in terms of power imbalances is as public agencies grow, it's becoming, the haystack is just getting bigger and bigger. The amount of data, text messages, emails, folks could be using apps where the text messages are deleted. There's actually no retention policy for text messages unless they're the subject of litigation. And there's no strict retain, but they can be just sending stuff and deleting it. So I think the challenge for the public is understanding how public agencies work, understanding what records to ask for, understanding how to ask for records and information and data in a way that's effective. Because there's so much out there that, okay, I want emails with these search terms, and then they come back, okay, well, we got 10,000 hits, so we can do it, but the special service charge is $5,000. No one's gonna go for that unless you're wealthy, or maybe sometimes you could be like a big company and it's worth it, right? Because you're in business for that. But for folks like us, yeah, we're not going to spend thousands of dollars so someone can sift through emails. And there could be a really important needle in that haystack. But the challenge is that everything is becoming so voluminous and so technically oriented that's a whole separate and independent challenge to the public in terms of access.
Well, that's what
That actually leads me to a real question. Are there resources out there that help someone figure out how to ask for what they want?
Exactly.
Are there any? Yeah.
There's some stuff out there. I mean, the ACLU, it's a little dormant, but the ACLU had transparency information on its webpage. I'm on the board of the New Jersey Foundation for Open Government, and we've got some transparency information on our page. John Path blogs. John's probably the best, even including like the OPRA blogs. And my firm's got an OPRA blog. CJ Griffin and Passion Stein is a transparency blog. But John is a master at plain English blog posts, short, to the point. He's a master at settlement agreements. So just look at what John's requesting and request that. That would be my advice. And so the information is out there, and look, it's OPRA, so there's not going to be like 1,000 blogs on it. There might be 10. So it's just that much of a challenge to find it. But my first look, I should be like marketing myself, right? Oh, go to my blog. But my first look would be to John, because John is not an attorney. He's completely self-taught. To the level of successfully doing pro se cases, more Meetings Act than Records Act, but totally self-taught, and he works very hard to communicate what's important to other folks.
Well,
So one question, I'm sorry, Sean, did you have anything?
No, I was just saying thanks. That's all.
I'm starting to get annoyed with all the extension requests, and I know that when COVID happened, there was like this, I think a rule came in where, I think it was New Jersey. I don't know if it was everywhere, and I feel like it's just being consistently abused. And I know journalists have complained about it, and media outlets I think have been the largest voices, saying, hey, listen, when is this going to lift? But I feel like every response now that we at least get from the district comes with a 30-day. Now they just hired they've hired their 10th business assistant position or whatever the hell's going on there. And we're still getting 45-day extensions on this.
I just got one today, 45-day extension.
And there are statutes of limitations too, if there's an ethics violation or something like that. So it feels very gamey. Is the state going to kind of go back on that? Like, what's happening with that, Walter?
That is a very difficult question. And I frankly, I don't have a good answer, because OPRA says 7 business days, but 7 business days is honored in the breach. And in my experience, judges are reluctant to come in and micromanage the number of extensions. How much is too much? I'm not sure. Do I think that 6 months is too much? Is that the point where I think I could file an OPRA order to show cause and get a judge to agree with me that 6 months is too much? Yes. Is 30 days reasonable? Even for the sort of immediate access records, which again, honored in the breach. Unfortunately, I've had a very tough time trying to enforce, like 20 days, 30 days, 40 days.
Even if there's like a pattern, even if it like is a standard response, still hard, right?
Yeah, because it's hard to get insight into how the records custodian is processing requests, because on the one hand, they should be processing requests in the order in which they're received. On the other hand, records custodians get a lot of repetitive requests that folks asking for the same information, the same types of information, so they're easy to fulfill. Like, okay, here's the request for the accident reports, or here's the request for the certain types of data. So they just get that out. And then requests that require searching emails, or maybe requests that have a lot of subparts, those are going to be complicated requests. And the other problem is, from my perspective as someone who wants to take OPRA cases and wants to take OPRA cases on contingency, for me to get fee shifting, so I'm in a position to offer contingency, which I love to do. For me to get fee shifting, I have to show that there has been a denial of access. And the challenge becomes, okay, when do a series of extensions amount to a denial of access? Because if I come in, I file a lawsuit, the opposition is going to say, hey, well, wait a second. We asked for a bunch of extensions. We were reasonable. Here's the 10 reasons why the extensions were reasonable. And here's the records, but we're not giving the records because Mr. Luers filed a lawsuit. We're giving the records because we just need a little bit more time. And so it becomes more difficult in that under those circumstances for me to offer contingency. And I just say, just keep following up, create a good track record. So it's tough. As you can probably tell, I've struggled to answer that very question, because I think there's a lot of risk from the perspective of what can I do in terms of getting a successful result for you, for people like you, and getting fee shifting. Just there's a tremendous amount of risk. But again, it's part of that feedback loop, right? There isn't a culture of transparency. There's more of like a culture of opacity. So as a result, there's more OPRA requests, and the OPRA requests become more detailed and they become more sophisticated. And so the responses require a lot more work. And then in turn, there's more extensions, which in turn reduces trust. And
So I have a question. Is it okay if I ask a question about OPMA?
That's the that feedback loop.
Yep, sure.
Is it okay if I ask a question about OPMA?
Oh, absolutely.
Sure. So one of the things that we've noticed 2 times, what's happened is we've identified an issue with OPMA. Once was me, I think Laura, you and I were in on one, and then I think Dipti was in on a second one. And then the prosecutor's response is, oh, the district is wonderful with OPMA, but hey, they're going to make all these changes. And it's essentially a de facto kind of settlement. And it feels like there's a big reluctance on the part of, say, a prosecutor's office or state agencies to sort of push OPMA. I don't know if that's been your experience, and if you could explain maybe the reasons for that.
Well, I think from time to time you'll get a good letter from the prosecutor.
Yeah.
In the history of the Meetings Act, which I think is 45 years, I'm not aware of any civil action brought by a prosecutor to enforce the Meetings Act.
Wow.
It never happened, but I'm not aware of one. And you think I'd read about it, because I try to read every single Meetings Act case there is. So I'm not aware of any. I don't think there's ever been one. But different offices will issue letters, and that can be very powerful. No one wants to get a letter from the prosecutor's office. No one wants to even be on their radar. So I have seen letters. I mean, Burlington County comes to mind.
Yeah, I saw that one.
Yeah, that's made the rounds, right?
Yeah.
So some offices will say, look, you did this. We don't think we think it violates the law. They'll use softer language than that, but say, look, don't do it again.
So the best that we got, basically what the best is, like the best outcome we could have expected is what we got, which is a letter basically saying change this shit.
I think that's an excellent outcome.
Okay.
Especially when you consider that there's no fee shifting in the Meetings Act, and there's a lot of challenges. In OPRA, the law is set up where there's a presumption of access, which means you're supposed to get the record. And if I file a lawsuit, if it's a gray area, I'm supposed to win. The Meetings Act is much more balanced. The public agency has the right to regulate its own meetings. In order to get a permanent injunction, you have to show a pattern. How do you prove a pattern? And the statute of limitations is still 45 days. So you have a lot. There's a lot of challenges. So I think a letter from the prosecutor is a win, and I think those letters tend to be very effective in adjusting behavior.
Well, that's good.
Any other questions, guys? I have a couple more lined up. Go ahead, John.
I wanted to see if it's acceptable to ask Walter, top 3 things you see threatening New Jersey from your point of view.
Oh boy.
Not including John Leo.
I'm one. I'll give you just say 2 then.
We certainly touched on one of them, which is that it is becoming impossible to track almost anything, especially spending, especially at the higher levels. But even you have counties that I don't know if there's counties that have a budget of $1 billion yet, but I know there's counties that have budgets of several $100 million. So I think it's becoming impossible to track spending, track conflicts, track nepotism, track favors. Like, how do you do that across multiple agencies, even when you know who the insiders are? So I think there's a very big threat to that, because you get the same players getting the same contracts over and over again, and that does increase the risk of corruption. So I mean, that's definitely number one. That's a big one. Number 2 is, I mean, post-COVID, I saw an increase in participation, but it's not really playing out now that we're like during COVID, I saw an increase in participation, but post-COVID, it's kind of wearing off. And I think we may be running into a tremendous missed opportunity where during COVID, we used technology and public agencies used technology to really vastly increase access. So under the emergency regulations from DCA, a public agency had to give public access at the same level that they were giving the public agency access. So for example, during a meeting, if the governing body had Zoom, public had to have Zoom. If you had Zoom, you had to be able to make public comment by video. If you didn't have video, but you could send it an email, they had to accept that. They had to have a conference call line if you couldn't do Zoom. I mean, that kind of access was amazing. And I think a lot of that's really been walked back. So I think, is it a threat or is it a potential failure that I think public agencies have really missed a tremendous opportunity to just have everything completely open. And that's very challenging, but it can also be like a little scary. It's like instead of having like 3 people at a meeting, now you've got 200.
Well, that's actually an issue in our district. So our district actually voted to, on some level, had this plan to, I think it was like $10K to invest in continuing access via Zoom. And then when all this stuff went down, when they were found in violation of bidding laws and nepotism and all this stuff, they shut down social media. All of a sudden, Zoom isn't happening and hasn't happened. When people started getting involved, asking questions and finding out what was going on, all of a sudden, all those things got shut down.
Shut the door.
And I think so some of it could be a failure, but I think some of it could be intentional, to be honest, in my opinion,
Yeah, I mean that's a big problem. That's a huge problem. And the money's there, right? I mean, how much does it cost to get a corporate level subscription to Zoom, or it doesn't even have to be Zoom, because there's a lot of providers. It doesn't cost a lot of money relative to the tax base.
It's less than a business assistant.
I'm sorry?
Yeah, it probably costs less than a business assistant. That's an inside joke, Walter. I'm sorry.
That's part of the culture of obesity that I'm referring to. And yeah, like, folks start finding stuff out, and then now no more folks are coming to meetings, more folks are making public comment. And yeah, there's nothing, it's completely legal for a public, and we don't even have to make, Berkeley Heights like the whipping person or the scapegoat, but it's perfectly legal to just cut back on that. There's no requirement. Now, maybe someday someone will say, hey, under the Americans with Disabilities Act or some other law that deals with access, if someone has a problem getting to the meeting physically, then you have to set up alternatives. But that's not something that we have right now.
All right, guys. Anything else that you guys wanted to bring up? I feel like I could go on forever.
Yeah, this is good, Walter.
All right, so I just have one more, Walter, I promise, and I'll let you go, okay? So I guess if you were in a room with the Board of Education or the superintendent of our district, and you don't have to get into any of this shit. I know there's this whole law thing where you're not supposed to talk to people, and you were to say, like, what is it that you would say to them, like, to solve some of this, to solve these problems, to start getting people to trust you again, or to start building relationships back with the community, and you have like a minute to talk to them, what would you kind of say to them?
Be more transparent. Make it easier for the public to access information. Err on the side of transparency. That's the best way, because once you start doing that, you start getting back a little bit of trust, and then hopefully that feedback loop reverses itself, where now folks are getting the information that they need, and you're having fewer lawsuits, or maybe you're not having any. Like, most towns never have OPRA lawsuits in any given year. Okay, or maybe they have like one. Okay, now sometimes you get.
We win again! Yay, Berkeley Heights!
Berkeley, number one.
Number
one.
Sort of like, I mean, I would tell, look, make it a point of honor or a badge of honor that you can respond to OPRA requests and be so open that maybe you only get tagged with like one GRC complaint, or maybe you only get tagged with one lawsuit. Because like there are some lawsuits out there that maybe they should have been lawsuits, and I'm talking about statewide, not Berkeley. And there's some GRC complaints that maybe they should have been GRC complaints. But when I work with towns, and I do work with a few towns, it's I make it a badge of honor to be open and to avoid litigation. So that means when there's any doubt, provide the record. Only redact or not provide a record when it's really there's really a strong interest. And the other thing is you have to be more disciplined about your communications. I think certain places, okay, there's text messages, there's emails, the members of the governing body are having lots of communications. Like, no, it's not your job. Your job is not to be involved in every little element, because that's part of the problem. When the governing body just tries to have its hands into everything, they're creating all these potentially responsive records. Like, no, just you're supposed to be like the top level of the government. So be the executives, just govern. Don't try to administer and create like all this work and all these responsive records and have your hand into everything. Just relax and let your administrators and your and the people whose job it is to run public agency just run it.
All right. There was one more thing I wanted to sort of end on. Oh, go ahead. Would you want to bring up your firm, where you're located, or phone number, or contact information, or anything?
Okay. Yeah, sure. I'd be happy to. So I'm a partner at Cohn, Lifflin, Perlman, Herman, and Knopf, and we're located in Saddlebrook, New Jersey. But the work that I do and the work that most of my partners do, it's statewide, and we even right up to class actions. So like we do some stuff that even has like a nationwide scope. My practice is still litigation, and it involves a lot of Open Public Records Act, some civil rights, some commercial, some Meetings Act. It doesn't come up a lot. But yes, our we have a catchy website. It's www.njlawfirm.com. Right.
How did you get that domain?
I don't know. I wasn't involved in that. I wasn't around at the firm when they got it. But yes, great catch. Right.
It is, yeah.
But that's where we are. That's where my blog is. And we're a full service firm. So anything that folks need, doors always open. I personally try not to get too pigeonholed into OPRA, but I love it, as you can probably tell. I love talking.
So if I'm feeling like kind of lonely at 11 o'clock at night, I need somebody to talk to.
There you go.
Can I give you guys a call?
Anymore. Stop calling me. Walter, are you ready for the onslaught of business you're about to get after this goes out? Careful.
All our 5 viewers.
Go viral.
Walter, thank you so much, man. I know you're super busy. And you have 6 kids and a Jets fan, and those are all hard things. But we appreciate your time. We hope to have you again sometime in the future if you're open to it.
Yeah, no, it's a pleasure. I had a lot of fun, as you can probably tell. So yeah, doors always open. Anytime you want me on, just send me a note. Happy to be a part of it.
Awesome.
Thanks, Walter.
Thank you, Walter. Have a good night, everybody.
Awesome.
Bye.
See ya.
Bye.
Bye-bye.
Bye.
There.